You don't need it. You can't cite it. Please don't cite the police report. You refer to the statements of witnesses or evidence, but not police report.
In fact, it doesn't form part of the proof of evidence.
You see? So, any other question or comment?
Maybe in addition to what Monty just asked, Conrad, sorry. The issue of letter forwarding, the case that was forwarded to this solicitor. Don't even, maybe someone will say, since there is no letter, I will just put the date that it was assigned to me. No, don't put the date that the case that was assigned to you by the department. Just refer to the case that it was forwarded to this ministry for legal advice. And that suffices.
Yes, ma'am. What about the date that it was accepted in the office of the Attorney General? Won't I make reference to it by saying that we are in receipt of a contract diary forwarded to this office on so date?
Yes, that one will suffice. Yes.
Yes.
That one will suffice. Because at times, there are 2 dates here that we're talking about. The letter may be dated 10, but the office received it on the 12th. So you have 2 dates. And if you're quoting any, you should do it properly. If you are referring to their letter dated this, forwarding this, different, or this ministry is in receipt of your case diary on so date.
Thank you. Now, you see, you need to make reference to that if there is. Why? Because when you do that, you are tying them to their letter, their correspondence. And you know the style in this office is that you also say, sometimes the office will insist that you put that so that it will show that you took too long a time to profile your advice. So you judge yourself by yourself. I agree with that style. So that, yes. So you put the date on which the office received it, and you will now be shown that it's you that has inordinately delayed the advice.
And we should also be mindful of the provisions of after
14 days.
14 days within we prepare our advice. 14 days. Let's try.
Yes.
Let's try to meet up, although we have challenges.
Yes.
That respect.
Yes.
With time,
Yes.
we can overcome all these challenges.
Okay. Before we leave the issue of legal advice, let me briefly talk on punctuations. Punctuations before we leave the issue of legal advice. It's still an aspect of the legal advice. Punctuations. Now, the rules of language hasn't changed when you are writing a legal advice. The rules of drafting hasn't changed. You are applying it because it's language. Syntax. What is syntax? Can somebody? What is syntax?
Syntax. Arrangement of words and phrases. Arrangement of words and phrases.
One house, please. Yes.
Syntax is arrangement of words and phrases that will make meaning.
Yes. Any other contribution? Yes, arrangement of words into phrases and sentences. Words that are arranged because one word and the other is the word is, and another word injury. Arrange them to form either a phrase and then additional words, or if those two can make a sentence then into a sentence, as the case may be. So, what is semantics? Semantics.
The choice of words.
Words and their meanings. Meanings of words. Semantics. Meanings of words. So, like I was saying earlier, police, in trying to write their whatever report about a case, they use words based on their understanding, based on their level of education. Me, my my book, my knowledge, now like this. So whatever is going to write to you will be based on his knowledge. But you are a lawyer, you are an expert. Therefore, if you use that kind of language, it will not work. It won't use the right word. Right word. If you've read or now have an idea on that case, use the appropriate word, not what the police wrote, please. If you do that, somebody reading will not understand your case or your legal advice. So use the appropriate word. That is semantics. Now, in arranging the words into phrases or sentences, syntax, you arrange them in a manner that will make meaning to whomsoever it will be presented. The legal advice will be presented. So you will have the combination of using semantics and syntax, just like in any other work you are doing. Now, punctuations. The rules of punctuations have not changed. The rules of punctuations have not changed when you are writing or drafting. You are supposed to deploy those rules in whatever thing you are writing. Whatever you are doing, you are supposed to deploy those rules. Now, if you wrote a statement, at the end of statement, what punctuation mark are you supposed to do? That rule has not changed. You abide by it, or the person reading it will wonder, say, this is coming from Ross. Is this the Ross I know? So, checking it. You know? You know, if you don't do that, why? So, if it is full stop, please put full stop. And the next sentence, how is it supposed to start? That too has not changed. Please. Please. What is a semicolon? I wanted us to have a board for purpose of doing some of these things. What is a semicolon? What's a semicolon? Please. What is a semicolon? Okay, what is a colon? This is what I'm referring to. This. I hope you will see it. I hope you will see it. This one. Can you see?
Yeah.
So.
That she cannot see. The one that is done.
No, these two. Just this one and this one. She can't see. Okay. So this is colon. And this is semicolon.
Yes, sir.
So, and you agree that both of them have functions.
Yes.
So what functions does, maybe you have challenge defining them, but what function does a semicolon does in a sentence or in a writing? Semicolon.
Yes, sir. When you have, when there's a simple sentence, there's compound and complex sentence.
Yes.
Then you can, when there's a compound sentence, for instance, you can use the semicolon now to kind of punctuate it so that it will make meaning.
Yes. Good. That's good. So when do you use a colon?
Colon is a punctuation mark that clearly indicates the intention to list out certain items, to list after a colon. What follows is the listing.
Good. A colon is a device. Okay, thank you. Thank you. So when I do this, at least you can see. Thank you very much. So a colon is a drafting device used when it is intended to number items or list things or number of things. The colon. Now, the rule for using colon is that when you use the colon, this is the colon. The next thing that starts after the colon, that is the rule, must be in small letter. Must. That is the rule. Except if it is a proper noun. Otherwise, now, for the avoidance of doubt, let's look at this. So, a colon, except if it is a proper noun, like, you know what a proper noun is? Name of a person, place, or thing. Except if that is what comes after the colon, then every other word or beginning of the word must be in small letter. So because we don't have a board, let me send
Maybe
this.
let's say like we're talking about countries.
Mhm.
Okay.
Yes, ma.
If we're talking about countries, we say there are.
So this was what you were told. Don't anyone happen? So now please take it down. This is what I'm referring to. This is the colon bar. You see this one A bar, the W small, B, C. All. This is what I'm talking. This section. Thank you very much.
So if the column is to list like, let's say Plateau State has the following local governments. One will use capital. But if it is like a sentence.
So, except if, do you understand what we're saying? If you start a sentence, you say, for the avoidance of doubt. For the avoidance, let's say, that's section 1, for the avoidance of doubt. Very. The following, the following shall not compete. The following shall not compete. Then you put this column. Then A. A. Sick person. B. Old,
Aged person.
aged, old or aged persons. C.
Minor.
Minor.
Minor. Minor or minus. Minus.
Oh, minus, okay.
Minus.
Yes.
Huh?
Good.
Can we see this? Now, you see, you've put a column. The rules of drafting in English and in every language is that, thank you, is that the moment there's a column, every other thing that comes on there under must start with a small letter. So this S cannot be capital. It must be small s. Then at the end, now mind you, this is still whether you list it, that section I've given to go around, you see, it's a lengthy one. It's just one sentence. I hope you understand. Even if it is 3 pages, it's one sentence. One sentence, and that is why here we deploy the mechanism, the drafting referred to as semicolon, 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 semicolon. And when we come to this, the last or second to the last one, how do we do it? Huh? And if we have D, if the last is D, then this one after the semicolon, then and. Please take note of this very well. When we are drafting, this is the way we want these things to appear. This is the rules of drafting. For the avoidance of doubt, please Google rules on capitalization. Google it. We have the challenges in the office where some people draft legal advice and then even improper. Okay, somebody say. But see space there now. Why are you hiding there? Sit and you want people to appreciate this thing so that carry a bomb this man. We are saying these things because rules of language have not changed, they are still the same. And so when you draft a legal advice or any document in the office, and then these rules are not being followed, then look at the two of them. Now, like the noun is the name of a person, place, or people. Now, nouns are quite exceptions. If it is a proper noun, then only the word will commence with a capital letter. But for an improper noun, you don't. So if you are
DPP, sorry, is it in all circumstances
No.
that when you list words or items like that, at the one before the last one must have an and? There are situations where you don't use an and. So
in some cases, O may be there. If it is disjunctive, if the requirements is disjunctive. Now you say, oh, then the last one. That is to say, all these requirements are independent of the other. Is that
They must not go together.
Yes. Yes.
But when you say and,
That means that
they must be.
conjunctive.
That's conjunctive.
So, so now, you see, like I said, when you are writing, take note of proper nouns and improper nouns. Improper nouns do not carry capital letters. Proper nouns do. If you are writing and you say a dog was killed, and it's the killing of that dog that led to the crisis. Now, that dog, why do you put that dog in capital? Do you need to put that dog in capital? It's an improper noun. But if in your writing, you've turned the dog into a proper noun, then that's the only reason why it will appear in capital. Or house, or engine, or any word whatsoever that is not proper. But let's say I say the dog that beat Mr. Audu was the dog that later attacked Miss Elizabeth. Is the dog they call Bingo. Bingo, that bingo, you can't write bingo now in small letter. It's a name. So bingo, but bingo is a dog. So now let me. I said if you're writing about a dog or a house or a farm or a shoe, these are improper nouns, so they carry small letters. But if in your writing you make them proper nouns must appear in capital letters. So in that case, you will carry capital letter, like the shoe, or you've given a name to your shoe. Given a name to your shoe, like you say, Queen Elizabeth. That's your shoe. That's the shoe. That's the way you value your shoe. Or Queen. Queen. So anybody on seeing Queen will know it's referring to that. That's how special you interpret your shoe. And then this device we use, and it will help us a long way when we are drafting. The nominal complainer, we say so person herein after referred to as the nominal complainer. It will help you a long way. And when you say the nominal, you define it. Nominal complainer is not proper now. But you say herein after referred to as the nominal complainer, you have made it a proper noun. So the nominal complainer, that nominal N and C will always come in capital letters. Or suspect, herein after referred to as the suspect. So suspect will always come in capital letter because you
give it the noun.
Give it, that is it. Proper noun. That is it. Or suspect or nominal complainant or the whichever one. If witness, the witness or first witness or second witness or first suspect or second suspect. So that is a device. Decode this device and it will help you a long way because you don't need to be repeating the name of the place. It makes it clumsy. When you each time you repeat the name of the person, Next time you repeat, or you say second suspect. Again, when you are referring to that person, second suspect. Next, 4 or 5 times or 10 times you are referring to that, you keep saying second suspect. You've told us who the second suspect is, for Christ's sake. Please, make it tidy. When you define a person, then keep referring to that definition. We be consistent. Be consistent. But before, let me say this before we go there on this issue of
We need 1 week, sir, for this. Very important.
on this issue of so like I said, Google capital, Google one house, Google rules on capitalization. And now, when you Google rules on capitalization, capitalize the first word of a sentence. Capitalize names and other proper nouns. Don't capitalize after a colon. Don't capitalize after a colon. Capitalize the first word of a quote. If you are quoting somebody, quotation marks, either double or single, but the first word there must come in capital. Now, capitalize days, months, holidays, not seasons. Now, when you are writing a heading, you capitalize major words. The day of the jackal. The day of the jackal. How do you spell jackal? Huh? See? Jackal. Now, the rule says capitalize the major words. So now you are starting with this, so this thing must come because you are starting with it. That's the rule. In this heading, day is a major word. For the purpose of this, day is a major word. Of, day is of a major word here. No. So you don't capitalize O. They here.
No.
No. Jackal.
Yes.
So these are the ones you capitalize. You capitalize. That's when we say.
For example, in the middle of a sentence, you're making reference to, for example, the Fulani man. So the Fulani should be, the F should be capitalized.
Yes.
The word of the man, the M.
Oh, the M should be small. It's Fulani. Now I'm even coming to that. Now, and this is it. I say capitalize most words in titles. So like this one that we just shot here. Names of cities, names of countries, companies, religions, political parties, and also proper nouns. Capitalize nationalities, languages, capitalize time, periods, and events. Proper, yes. I missed this one. Capitalize. Capitalize religions. So when you are mentioning a religion, you capitalize that religion. The language. Language, yes. That's your question. The language. Fulani is a language.
Yes.
So you capitalize. Mugufuli is a language. I don't know how to pronounce it. I want to spell it, pronounce it the way they do.
As spelled.
Pronounce it.
The pronunciation is different from.
No, but I want to pronounce it.
Probably.
That's what I wanted. That's what I wanted. Because I know they pronounce it different from one to see. So, see, so if it is Fulani, if it is Giron, You don't put it in small letter. It should be capitalized. But a man is a man. Fly man. Bureau. February, June, Sunday. Then let me tell you this. Please get this app. I have it on my phone. Get this app called Grammarly. 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 Grammar. Please install this app on your phone or your laptop or whatever system. It will guide you. If you write wrongly, it will put danger for you. Grammarly on your Android device, it will guide you in a wrong way when you are drafting. When the moment you go wrong, it will tell you. So again, the rule is that doubt, please don't capitalize. Please, when in doubt, not in doubt, capitalize. But whenever you have a doubt, please don't. Just leave it like that. Again, we have these rules in drafting. There's the need of being concise, the need of being comprehensive. You write in a way that is comprehensible to whoever will read. It should be concise. Don't keep windy, long statements. Lawyers in those days, they write plenty because that was the nature of the trade. They were paid their fees based on the number of words used. Now it's not like that. And in any case, nobody is paying us. So why do you write what is supposed to be in 2 lines to be in 2 pages? Please, concise. Then consistency. Be consistent. That's why if you define somebody as the first suspect, then keep referring to that all through as the first suspect. Please. Or if you've said the nominal complainant, each time should be that person. And then if the nominal complainant, you've been using it capital N, capital C, nominal complainant, then when you are doing that in another line somewhere, you turn to small, it's clumsy.
Or at times, maybe you say Vincent Brown, herein after referred to as the nominal complainant. So at the body of the advice, you'll be referring to Vincent Brown as the nominal complainant. But when at one point when you say Vincent again, which Vincent are you talking about? When you have said he's the nominal complainant, you don't need to do that. Just stick to the hearing after referred to as. That's the one you stick to the end. Don't be using this.
Thank you, ma'am. So, except if somebody has a question, we will.
Yes, sir, I have a question. So based on what you just said about the punctuations, capital letters, and all that, how can we now reconcile, like basically, when we are preparing legal advice, when it comes to you, based on your corrections, we go back to what you said, but when it goes back to the AG's office, the correction changes, like what he said, the Fulani man. So the Fulani is now in capital letter, but the man, when it comes from the AG's office, is in capital letter.
Well, you see, even before my Lord Justice Longday now, when he was here, he was saying, drafting in that manner.
Yeah, yes, sir.
Well, Except the rules in drafting have changed. This is what I know. Some of you here are witnesses when in either Justice London or even the AG. Now, these rules I said on draft, on column, some would have witnessed here when it went upstairs, they now start the words in capital.
Yes.
Well, except the rules have changed, me, this is what I know. I'm coming. Except, like I said, except, you see, when doing an affidavit, when deposing to affidavit of facts, affidavit, you see lawyers keep paragraph 1, capital, that in capital. See, that's not correct drafting. But lawyers have made it in a manner that is acceptable. So it has become acceptable practice. It has become notorious that that's the way it is done. Even though it's incorrect way of drafting, it has become acceptable to the courts. And they do it like that. Again, most lawyers are there who draft things anyhow. Imagine you were in private. Is it not so? If you've not been corrected, you still be drafting like that. But these are the rules. These are the rules for drafting.
Sir, I appreciate what you just told us and it has made a lot of sense. And in addition to what Khaled just said, I wanted to talk earlier on when we were talking about the delay in writing legal advice and corrections and all that. At times you will correct, Ogalon then you will correct like 2 times. You understand? So before you now get to the age, so that also contributes in the delay.
Well, you are right. now, yes, yes is here. How do we handle this?
Yeah.
You know the rules, and then we do it following the rules, and then the lead counsel now says it should be capitalized. How do we do it?
You know, as it is now, when you look at legal advice from DPP's office goes straight to the AG. This is to cut some bureaucratic processes and in view of the provisions of the law. And as we are all aware, we attended different schools. But if you should, for the example that was given, Fulani man, I think whether you say the Fulani should be capital and the man should be small letter, and AG is saying the man should be capital, I think that is by way of emphasis. It's by way of emphasis. And depending on the context you are using those words. You know, English is English, is somehow. So the issue of vetting, you know, the director must vet, and the AG being the head of the ministry and the spokesperson for the ministry is the final say. Anything, we always say it. Anything that is going out of this ministry, he must see it first. Whether you're filing or it is a letter that you're sending out. Because if there is any issue that arise in respect of that, he's the one that will be called upon to say 1 or 2 things. And at times he might be embarrassed elsewhere because he will not know about these things. But I think the issue of delay that you are talking about, well, I think it's okay. It's okay since the legal advice doesn't come through my office, from the director's office straight to the AG, and you know the workload too is there, and he needs to see it because it is a legal advice. It is going out of this ministry. It would have been different if it is a document that would be within our ministry. It's better. You know, most of these ministries rely on us because they are just waiting for, it's Ministry of Justice that says this and said that. So they will capitalize on whatever that is going on. So let the AG be for whatever purpose, please. Let's not be carried away by time, though it is a provision of the law, but we work towards it to see that we meet up with the time.
Thank you. So the AG has the final say. That's why when we write 4 and 4 Attorney General. Is it not so? So if I vet and he vets the way he likes, please, we will go by whatever he wants. But please, don't be laying like some people, somebody will write and they write somewhere and put car in capital A-C-A-R because he's laying emphasis on car. Then the person, each time you say car or toy or whatever word. You see, the way you emphasize the word is either you embolden it or you underline it. But when you now capitalize the word because you are laying emphasis, please. So the issue is if the AG vets, and some of you would have known, if after vetting and he corrects, I will usually say, let's go by his own way. We will abide by whatever he has said. So that's the way we continue to do it. Somebody.
And you know the rules of drafting. Nobody has monopoly. Even if it is your children or your colleague, when you write something down, give to somebody. Somebody might see what you are not seeing. So that is what, as lawyers, you are supposed to be doing. Not to think that you know all. What I've written is the final thing. Somebody must see it. Don't be in a rush. Somebody has to see it. And that is why we have an edge over all these other ministries. Because we write and we take to colleagues to look at it before maybe a superior will look at it before AG finally sees it before it goes out. Some of these ministries they don't have that benefit. And you know, this is even in law school, university where I taught to do that.
Thank you, ma'am. Now, before you were raising your hand up, before you talk and even you, let me say this. Please, when you draft and you print, please read it before you submit. I've observed this several times. You print and submit things that if you had read, you would have seen mistakes. Then you just submit like that. And sincerely with people that read your work form opinion on your work. Your work speaks volume of who you are. Whether you are here is empty or what is your work that tell people. Please don't just print something and forward like that. Please, I beg of you. If you do it, you are on your own.
Yes, sir. I wanted to address the issue of the fast tracking of the.
I'm no longer raising the issue. You say you wanted to.
Sir, I speak, you should be allowed to make this point.
Yes.
I think if we are equipped with knowledge in handling the computer computer is going to help a lot. If I type, for example, the legal advice, and I have the email address of the VP, I send it directly. He vets it in the system and forwards it to the AG immediately. Can be done even within less than a week. So if we are equipped with the knowledge of the computer and then the facilities are available to individual counsel, if each counsel is opportune by the office, provided with a system, you have available data connectivity. You type your legal, even if it's at home, you send it to, even at the weekend, can be sent to the AG, and within a short time, the whole legal advice is out.
Thank you, Demi. Thank you. You see, the lack of facilities in the office, but in due course, I think those challenges will be addressed. But for now, when you say if you are proficient in the use of computers, these people are supposed to be proficient, except some of us. Let me say it, because one of the prerequisites for attending law school was attending with a laptop. Is it not so?
Yes,
Are you not in that age bracket? Those who attended law school with computers,
Yes,
except some of us.
We are not saying that the office should have the way of equipping us.
No, I said that. I agree to that. Please, when those challenges of facilities are addressed in the office, I think we will overcome that. But for now, the issue of facilities, we have even advanced the reason that the desktops in the library be given to lawyers or but then the office has not yet seen, well, because we've not finished paying for them and things like that. So no, I'm not, nobody has given you permission.
It's just an emphasis. For emphasis, you said after writing the legal advice,
Yes.
you should ensure you achieve it. Like I said, it was for emphasis. Take for example, aside from the person reading it, using the example of the ATL network, for example, I can assure you hardly hear errors in terms of grammar in any of the ATL networks. The reason why we have successfully presented the news without grammatical error over the years is because of the processes. In the newsroom, you are told, whenever you write your script, the first thing you give your colleagues. He goes through it. Because even if you read it on your own, there are some errors you don't do not detect. But your colleague may be able to point it out. Then it goes to the sub-editor and then to the editor and then the news producer. With all these stages, by the time it goes through all these stages, at the end of the day, it comes out almost error-free.
Thank you. You see, one other thing again, before there are some, in fact, if we had done this stepping down training, one of the topics we would have taught has to do with the use of redundant words, like padding, redundant words like or colloquial words. We need to abide by the new school in drafting. As a new school in drafting. But that training is not very possible. So just to mention this on the periphery. But if we had done that, we would have gone with typical, that's a topic, the type of words to use and the words not to use and things like that. Like, let's say I give an example with a statement like, it is necessary, it is pertinent, it is important, it is germane, and purpose.
It is gargantuan.
You know, redundant words, redundant, you are not supposed to. You know, Someone will say for emphasis, please calm down. Old English, no longer needed. Huh?
Instead of what?
Huh?
What's the word we are?
If I say it is important, that's okay. What's your name? Just the word, not party, not party. One house.
I read on this motion.
One house.
And so I just want to make a little observation and addendum to what the major said, sir. You know, like this legal advice is a recurrent issue. Every day, legal advice keep popping into the office.
Yes.
And I now realize that your office is quite flooded with a lot of, you have to read this, read that, proofread, correct, send. And in the course of doing that, some of us too, like last 2 weeks ago, I tried to send a document, but of course there is no email for us to send documents. So I had to go through the normal process of printing the hard copy. I lost my flash drive. I went to fix the system. They said in fact it has affected even the hard drive. I had to spend like 17,000 naira to bring back the laptops. So if I may suggest, sir, with the kind permission of our PS, if there's a floodgate of blessing from Ministry of Finance to the ministry, if we can get laptops for the head of departments, and probably with the stipends for data, so that if I finish working on a document, I just forward it to the email of Ogalonji. He will open it, maybe make corrections, and then send it for printing. Instead of everybody will bring his process, we infect the system every day with virus, it will be easier. And then, of course, it will save a lot of time. Because the director will be very busy with other tax rules, maybe meetings, but maybe at your leisure time, you just go through your email. Perhaps if I had sent it, you can just relax and then go through it. It will even lessen the work for Monday. So if we can look into that, let's take advantage of the technology and the ICT. Honestly, it will bring a lot of innovation. Thank you, sir.
Thank you very much. Because if we deploy the use of technology, it will go a long way. The dividing of papers, the printing, all the stories. But when you send a legal advice or a document to the person you want to help you read or your head, you can text the person and send also mail to you by text message or call. The person will go through it, and the use of the issue of printing, typing, and whatever is obviated. You don't need to. But I pray that in due course these issues will be addressed. Yes. Now, Revlon, Lillian, come, and Ibro, come. Very, very late. Come forward. Go to my office. You're coming late. Go to my office. I feel we need to take refreshment before we continue. Look at the number of people here. Okay, the attendance. Where is that? So write your list and then go
in the video evidence.
you will have to be people because I don't know how this goes. So, now,
You got it.
One house, please. One house. Issue of charge. Yes. Issue of charge. You see, I think, okay, so for drafting of a charge, the drafting of the charge will be dependent on the nature of the offense in question. I hope we all understand that.
Yes.
So when you are drafting the charge, you look at that. The law has provided that the charge is not if we are charging, but if the police are doing their own, we have to investigate. But if we are doing our own, we have to come with the name of people of the parties. People. Yes.
People of Plateau. Yes. People of Plateau.
Okay. So that's how it's supposed to be. And then you know that after writing the parties, then the charge, then the count or counts, as the case may be. Now, if it is many counts, you start with count 1. After saying the count, you go to particulars for that count. And then you go to the next count and the particulars as well. The law is not strict on the language you should use there. So you use your own language in how to put to capture it or draft it. But please do it as an expert. Draft like an expert. The law is not provided it is understandable that the person being charged should know that the state is proceeding against him or her for this offense, describing the offense in the particulars. Now, like we say, count 1, let's say assault. So count 1 that you so person at so place on so date at about so time within the jurisdiction of this honorable court committed assault on so person. Oh no, that's the particulars. That you so the offense of assault contrary to section so and punishable under section so. That's the count 1. Count 1. The particulars now we now say that you so person of on so date or time and then at so place to which in that. Now what's the meaning of the phrase to which? To which is Latin. Is Latin. To which that is. You if you say to which, the next word should be that offense. That is, you committed the so to which kidnapping. When you and so persons arrange or whatever and kidnap criminally or what you describe those particulars and for ransom if it is kidnapping. Of course, because the issue of kidnapping will have to go with ransom. So you now describe the particulars. And thereby you conclude committed an offense and thereby committed an offense. Then you now get and sign for a charge. But in drafting a charge, you look at the provisions of that law in which you are charging. Please look at it. Don't over. Like we had said earlier, check note, new laws have come on board. If there's an extra law, be careful so that you don't charge under the old law when you are supposed to do under the new law. So let's be careful when we are doing that. We've had cases where somebody overlooked and then the director over also overlooks and until the AG saw it. It's supposed to be the extra law, not the old law. So please let's take note when there is a new law in place so that our drafting will reflect the new laws. Now, please, on the charging, let's release it. Yes.
So when you are talking about the charge, so you have to state the offense, statement of the offense. If we state the offense, it's not contrary to this and this section. Then under the particulars of the offense, we also say we have to say that you so person know about this time you committed an offense with, and we state the offense again. Wouldn't that be kind of a
change? I have said in opening that the law does not require you to look at the laws on drafting of charges in the penal code. It doesn't give. I'm just giving an example when I said that. It's just an example. The law says, provided by the way you draft, it is understandable that this person is charged for offense that suffices, and it cannot be thrown for reason of inelegant drafting or whatever. No, the charge will suffice, provided the defendant understands that which is being charged for. That suffices. Yes.
Yes, sir. Sorry, in an event where I decide to use the method we have been using under section 221 of the penal code, that is when the offense is called homicide, punishable with death. That is, for example, I now say that you, Mr. ABC, on or about so at so place, so time, committed the offense of homicide. You kill so person who is now deceased, contrary to section this and punishable under section this. Will it be okay, or must I stricto sensu follow the statement of the offense before coming back to the particulars of the? Must I, or if I use the other method, is it also?
Okay. You see, the old penal code has its own style,
yes,
which has been replaced by the new penal code. So if you go by the old penal code, it's like you are leaving the extant law and following the provisions of the old penal code. You understand?
The question is that you say if the defendant can understand.
No, but
yes,
see, I'm just saying, please, there's no hard and fast rule about the drafting, but that abide by the law, the new law, please. The old law did not put particulars differently from statement of offense, but this one does. You understand? By the old penal code, there's nothing different. There's no statement of offense. There's no particulars of offense. But this one now provides for particulars of offense, statement of offense, and particulars. So let's go by this new one. Thank you.
Sir, on the issue of this on and about, why you are stating that the offense was committed, also you even know the time. Can we just dispense with on or about?
No, that's a reason. Sometimes the time is.
Okay. Just say it down. Let's hold it.
Yes, sir. There are provisions where we use the word sometimes. Sometimes on or about, and it has to do with the time frame within which that
offense was committed. So if we say we're dispensing, then it means we're not getting the exact time frame within which that event took place or that act took place. That is my own.
So are you answering?
Just make
No, no,
slight
no, no.
adjustments,
Excuse
sir.
me. You are making a different comment.
No, I'm making a different comment because he is saying dispense with it. So, and so that brings me.
Okay.
I think the crucial thing is that when that phrase is used, sometimes or on or about when the offense was committed, the idea is to avoid a situation where you state with exactitude the time within which the offense was committed. Because in the testimony of the witness, he may variate a bit concerning that time. But you can't state with exactitude when the offense was committed. Exactly. So that you place a window period in which
No, because you may be surprised that in the course of trial, that time you were saying with exact may not be.
You may be somewhere.
So that is the issue. You understand? Yes. So because we are human beings, sometimes we make mistakes. Somebody, a witness who will tell you it was 12 midnight. He kept saying 12 midnight as if he looked at the watch. And sometimes your watch will not even tell you the so to avoid some the defense capitalizing on that, you have to know about. It's safer to do that. So let's leave the issue of charge now. Now we go to the issue of endorsements and facts. Gentlemen, it is please, why do we use this file? I gave you the answer. The
DPP,
Yes, ma'am.
I think this the use of file, I think is much more than the endorsement. This is because I don't know, gone are the days when the civil service, I don't know whether we go back to that, because files, normally you're supposed, once you're opening a new file, the file should be punched. Then as documents come in, as document comes in, you file them according to dates that are coming in. So apart from when we have that, and you have your proper endorsement, if somebody peradventure you're not around and somebody is going for the case, it will be easier for the person to just look at the file and he knows where to find what. Unlike now, you see files scattered. It will take you time to arrange, because you know the secret of, I like appearing in appellate courts, like Court of Appeal and Supreme Court, because if you know your file from the first to the last page, that is as regards your processes. When was the appeal entered? When was the brief filed? When was the record of proceeding compiled? You know, when you appear before these justices, they ask you one question, you give them answer. When they ask, they will say, he knows his file. So, in fact, it makes the work very easy, especially in this appellate courts. So I think the usage of the file is not just for the endorsement, though the endorsement will show you the case, is it civil or criminal, and the court before which the case is, then before where you how you have fared so far in the case and where we are and the next adjournment and what happened on so date. You have them on the endorsement. and the appearances too.
Thank you. Yes.
Sir, please, for the purpose of moving forward, if you can be helped with the information as regards to when you first receive a case, for example, a case diary that is coming from the DPP's office. Then my Lord Justice London, I was shocked to realize that upon receipt of the file, you're supposed to go to the legal registry for the legal registry to give your file a number. So I don't know if you can be helped in that regard as to what to do once you've been assigned a case diary.
Exactly, that's what it's supposed to be.
Okay, so
Yes, when a file, be it civil or criminal or mediation or whatever, either any matter that's assigned to you, whether a correspondence Madam, that water is not supposed to be given to everybody. You are giving minerals. Why do you? That water is for those who will not take the minerals.
everybody will take it.
Everybody.
That's all now.
No, I'm not supposed to be for what?
Where come from? Serve drink
So bring your money for that. Bring your money for that. That's not the water.
The water will go round.
You can't go
No,
around.
it's not that you're not.
You can't go around. See, so like I was saying, if a correspondence or a mail is minuted to you, the director minutes it to you, that mail. Upon receipt, you go down to the registry. They will look for the appropriate file of that mail, and then they will insert it inside. In fact, in those days, you used to just minute it to them there, but there are no staff now. They will now go and do it and bring it to you, but you don't have staff. So when the mail is given to you, you go to the registry. They will look for the appropriate file it, and then you now go and work on it. When you are through, you minute on the cover of the file. Those other types of files, not this case jackets. When that you minute it and then it's taken to the director, he will look at the page, what it is directed to him, like DCL, the page number and the paragraph as the case may be, and then the date. Yes. So he will look at it. If he sees it, he will go to the page, the relevant page, the relevant paragraph, and read whatever your minutes there. Then he too will do his own whatever action, and then go back to the back of the page, cancel your own, that which you did, and then insert that of the person is referring to there as you did it. That's for those type of facts. Now, for cases like this, you don't have the custody of the empty files. Is it not so? It's in the legal registry. So when a file is assigned to you, like let's assume this is the case diary, original case diary. So it's assigned to you, advice, whatever. You now collect, you go to the legal registry. They have this. So they will collect, like these numbers they write the number. They know how to do it, see the way they do on 3 sides of this. So you now put the legal advice inside. And that's how, number one, the purpose of this, number one, is to protect the documents. Could be many. Charge, motion for bail, counter affidavit, the case diary itself, and any other thing to protect them and make them safe. That's number one. So that they don't fly anyhow. And then the endorsement issue, like the PS said, the PS has she has said everything, but just for the sake of emphasis, case number, you enter the case number, quorum, then endorsement by who? Who are the council handling? If you are two, you ensure you put there. If you are two council that are handling, if you one council, you put there the quorum, the judge. Now, very important. This is not for naught that you are given this file jacket. That each time the case comes up, you go to your attend court on that date. And when the proceedings, whatever proceedings took place, if the case, the court didn't sit, you indicate court did not sit. And the reason, if the court did not sit because the judge is bereaved, just summarize there. If the court did not sit because the defendant accused was absent, you indicate there, or defense counsel, or whatever reason, you indicate. When you do that, like I said, summarize. Don't please scenario where just one day somebody fill the whole place here. Please. This file, if you use it very well, it will last the lifespan of that case. If you use it well. But you will now summarize this. And then when you do that, again, like the start some of us do, is we write here the date here, the date the case is coming up. Now, defendants in court. Defendants. If it is one defendant in court, you don't need to say first, second, third defendant. But you say defendants, all of them are in court. Except if one is not, then you indicate that second was not in court. Otherwise, defendants in court. Appearances, you don't need to say assistant director or whatever. You put just to have everything summarized. Now, if the court ordered for cost, you need to indicate. You need to, if some important things that took place in court, you indicate. Like, if the defendant informed the court that his counsel is bereaved, you need to say that so that you guide you against next time to know what happened, to know, like some counsel that will keep telling the court that his mother died. So
we're live, so all our comments. Be mindful.
So case adjourned to so they indicate that. Yeah. Case adjourned to, you put it. Now, if you case adjourned to 15th October 2022, then you come back here, put 15th October 2022. That's the next day that the case will come. Then on that day now again, you do the same. Please summarize. Don't put everything, but put important things on it. It has several
advantages.
We are here. Tomorrow we may not be here. I'm alive, healthy today. Tomorrow I may not be healthy. I'm in court today. Tomorrow I may be ill, or I might have traveled, or I might have retired. So, for whatever reason, when the file is now assigned to the next person, you don't need to read the minutes, the proceedings. You don't need on just reading this endorsement on this file, you just know that this case is adjourned to continuation of hearing. Or if PW1 was on the date PW1 was started, or all the witnesses, so would indicate that this witness was, if the case went on trial, and the number of witnesses that were taken indicate, so that when the person collects the file, the person will just see it. If I know that PW1 was taken as a new counsel now taking over this case, PW1 was taken, and I know that this file has been assigned to me, I will look and now go into the file, and if I know that the case is going on for hearing, I now have to go look at that, the notes on the evidence of PW1 to appreciate what PW1 said. So if I read that, I have an opinion, I will be strong. But when you don't read, you don't know it. But for the purpose of now, suppose you know that the court is not going to sit. And if the court is not going to sit on the 15th of October, here it said continuation of hearing. And I now have knowledge that the court is not sitting. Why do I need to go and be reading the notes? I don't need to read the notes for now, except if I have the time. But if the court is sitting and for continuation of hearing, I will have to read that note, read the notes, and go prepare myself, read the statements of other witnesses that are going to testify to make me abreast of the position of that case. So when you endorse, it helps a lot. But when you don't, that's why you can
Yes, sir.
because when the file is given to another person and the person does not know where to, of course, please. And that is the challenge when a file is given to somebody and because endorsement, the file is not endorsed and you collect, you wonder whether or not what the person is telling you is correct. We are human beings, we are prone to forgetting things.
Mm-hmm.
You know, depending on your knowledge that yes, I was the one that went to court, and no problem, if you fell sick or you are unable to go to court and you want your colleague to go, will your colleague know those things you happened? Can't you forget some of those things that happened that day? But when you note them down, even yourself, it helps you. Remind your question. You'll be reminded.
Okay, I just wanted to also add up to their importance because there are instances.
We wanted to.
Okay. I want. Yes. Now the issue there is. Once you make an endorsement, the court, it aids the court as well. Because there are instances the judges they want to refer back to what happened in previous proceedings. And of course, their record book is always difficult, to go back. Some of them may have even changed their record book. Now, as a counsel, once your records are intact, you can be able to guide the court. And as to even a date, an event, occurred. Because he may want to know, refer to a particular day, a particular witness was taken. Now, if you're able to trace it from your file, you will just refer the court, and the court can easily track back and note whatever it had recorded. Then, of course, another advantage is we all know that hearings now, of course, adjournments are regulated, where the ACJ provides for numbers of adjournments. So it will also guide, because if there are adjournments, this case, so far we've taken so adjournments. Now, tomorrow, a counsel may want to take an adjournment, you'll be able to tell the court, this is the number he has taken, and all of that, and it will help you in, going on from there.
or if it's a counter affidavit or something, and it's argued on the front of the document, you can just endorse.
Sincerely, you can be queried. Do you know that?
Yes, sir.
I'm telling you now, so notice now.